Hi, this is the 140-160 class. I'm going to start out with some number drills. For the record, 7,118,239, 689, 50%, 1,874, $17.69, 7,622, $52,055, $24.86, 1,298,373, 2,700, $6.35, 9,146, 10.25, $89.45, $250,192, 10 million, 75%, $119.59, $405.06, 66,000, 83,670, $50.99, 1,200, 9.75, $28.79, 3,700, $152,439, 13,049, 8,834,756, $6.50, 100%, 15,209, $47,010.12, 18%. These are some telephone numbers. 527-3693, 676-1954, 981-3411, 774-5092, 583-6073, 479-2515, 972-9855, 609-8595, 714-1332, 985-3156, 881-2039, 364-4436, 701-8178, 824-6259, 537-4601, 707-0019, 763-9240. These are some times. 12:10, 10:58, 2:14, 7:20 a.m., 8:42, 5:26, 4:33, 6:01, 9:45, 1:15, 3 o'clock, 6:55, 11:25, 9:30, 7:12, 6:50, 4:35 p.m., 10:47, 2:59, 6:40 a.m., 12:05, 8:25, 10:52, 5:37, 12:17, 2 o'clock, 4:43, 7:54, 11:02, 9:36 a.m., 1:21, 3:13, 8:07, and 10:19. These are some ordinal numbers. 35th, 3rd, 60th, 22nd, 11th, 32nd, 68th, 71st, 13th, 46th, 32nd, 94th, 103rd, 12th, 84th, 62nd, 99th, 1st, 80th, 53rd, 317th, 101st, 33rd, 4th, 20th, 83rd, 210th, 11th, 50th, 2nd, 44th, 93rd, 115th, 39th, and 17th. Okay, these are some Tangle Tamers for the record. Licensed auctioneer, clandestine rendezvous, bodily injury, questioned credibility, electrical impulses, corrective lenses, exceptionally long-standing, correction inevitable, ombudsman condemnation, initial assessment, view-oriented homes, gracious entertaining, recreational vehicle, obsolete guardhouse, hot scrubber dishwashers, controversial reauthorization, future reconciliation, luminous oval tubs, covered porches, behavior modification, sense and sensibility, sensitive statement, louvered draperies, outpatient facilities, unusual friendships, paraplegic equipment, terribly confusing, high profile, fresh architecture, colorless environment, swayed precariously, striking impression, foreign secretaries, beleaguered correspondence, illegal immigrants, home builder extraordinaire, peripherally evident, inadequately explained, quietly persuaded, alternately pressing, accessories available, radiology department, foreign exchange student, physical therapist, constantly misread, discriminating consumers, extensive amenities, professional community, suburban campground, hand-painted balusters, international symbolism, microwave combinations, recently distributed, threatened species. Okay, this is a drill with all EX words. Exact, examine, exemplar, exceptional, exclusive, excrement, executory, exertion, exigent, exhort, extraneous, expectant, experience, expedition, expire, expropriate, external, extinction, extreme, extension, expunge, exploit, expenditure, expect, expectorate, exotic, exigency, exhume, exercise, exemption, excursive, exclude, exacerbate, excerpt, examination, exacerbate, different than exasperate, exacting, exactly, excess, accept, examinee, excretory, excursion, exhale, exhibition, exorbitant, expansion, expansive, expendable, explode, exponent, expurgate, extinct, and exuberant. Okay, this is practice from our admonitions, stipulations, and motions book. This is an admonition for the record. You realize you have been placed under oath by the court reporter. Even though we are here informally in this room, it has the same effect as if we were in a court of law. That is, you are sworn to tell the truth. I would appreciate it if you would respond to my questions like you are doing out loud. The reporter cannot take down gestures. A nod of the head or a shake from one side to the other, or ahas and ha-ahs do not work. Also, I would appreciate it if you would wait until I finish asking the question before you respond, because first, the reporter can only take down one conversation at a time, and second, you may be responding to a question which is different from the one I intend to ask you. Everything that is said here today will be taken down by the reporter and put into a booklet. That booklet is called your deposition. At a later date before the trial, you will be required to read through the deposition, and at that time, you can make any changes in your deposition which differ from the testimony you give today. Let me caution you, if you make any changes in your deposition that differ from the testimony you give today, or if you testify differently at the time of trial than you do today, I can comment upon that at the time of trial. It may hurt your case and prove very embarrassing. So it is very important that you testify as accurately as possible today. In that light, I am not here to trick you, but just to ask you how the accident happened and about your injuries. If I ask you a question and you don't understand it, just tell me you don't understand, and I will rephrase the question. Okay, let's get started. You may use this chair if you prefer. This is a motion to quash. We ask that the court, pursuant to the 4th, 5th, 6th, 8th, and 14th Amendments to the United States Constitution and Article 12 of the Georgia Constitution, go forward to quash as unconstitutional the Georgia capital murder statute. We would like to state our reasons as follows. This is a capital prosecution, and exacting standards must be met to assure that it is a fair prosecution. It must be demonstrated that there was a specific intent to kill or inflict great bodily harm to support a capital murder conviction under Georgia law. Any plea of not guilty throws upon the state the burden of proving beyond a reasonable doubt each element of the crime necessary to constitute the defendant's guilt. To hold the particular defendant to an objective standard of reasonableness would be denying that an individual can ever harbor an irrational belief that he has no duty, and forbidding the jury to consider evidence that might negate willfulness would raise a serious question under the Sixth Amendment's jury trial provision. Petitioner argues that the mandatory nature of this presumption unconstitutionally shifted the state's burden of proving an essential element of this murder conviction. This circuit has previously considered the identical jury charge and held that the jury charge alone is unconstitutionally infirm. The fault in most of the instruction is that it does not give room for the unreasonable person in the development of the elements of the crime, malice, or premeditation. The presumption is erected that all people develop malice in the same way. It was unconstitutional to shift the burden of proving the absence of malice reflected in the mental state of an unreasonable person. We respectfully move that this court hold an evidentiary hearing and quash the Georgia capital murder statute. Okay, this is a stipulation on the record. May we, notwithstanding the new law, have a stipulation that the court reporter will be relieved, that the counsel for plaintiff will receive the original deposition and be custodian thereof under the new rules, that counsel for the plaintiff will, within a reasonable time, cause the plaintiff to review his deposition, that counsel for plaintiff will, in writing, advise all opposing counsel of any changes or corrections within a reasonable time frame, that if there is no such advice concerning any changes or corrections, it may be assumed that there are not, and that if for any reason the original is not lodged, a copy may be used with like force as the original, subject to the written corrections of which counsel have been notified, and subject to no corrections if they have not been notified at any evidentiary hearing. The parties have stipulated that the current stips are okay. Our previous agreements relative to earlier sessions are not abrogated by this. This is so stipulated by all parties present. But this is some congressional practice. For the record, Mr. President, I rise in strong support of cutting wasteful spending and closing tax loopholes. I also rise in opposition to this balanced budget amendment to our Constitution. I rise in strong support of fiscal discipline, but in opposition to a fiscal straitjacket that could cripple our economy and possibly even cause a depression. I rise in strong support of balancing our operating budget, but in opposition to using the Social Security Trust Fund to do it. I rise in support of a pay-as-you-go approach to the government's operating expenses, but in opposition to an amendment that ignores the fundamental principles of capital budgeting under which virtually all businesses and states operate. And I rise in strong support of holding Congress accountable for deficit spending, but in opposition to giving unelected judges the power to raise taxes and to cut Social Security benefits. Mr. President, I know that very deep public concerns have led to the consideration of this amendment. The American people have made it quite clear that they want to do more to cut wasteful spending, and I agree. We have made some progress, but there is still far too much waste, from top-heavy government bureaucracies to farm subsidies, the B-2 bomber, Star Wars, the space station, and a variety of special interest tax loopholes. We should do better. Americans have every right to be angry about the deficits and the waste that contributes to it. Unfortunately, the balanced budget amendment is not a magic bullet that is going to kill the deficit. I only wish it were. We must be frank with the American people. This amendment will not cut a dime of spending or close a single tax loophole. As many of my colleagues have urged on this floor, it is critical that before this amendment is approved, its proponents should tell the American people how this is going to get the job done. Unfortunately, so far, we have seen very little inclination to do so. Proponents do not want to tell the people that taxes for ordinary Americans could skyrocket. They do not want to tell the people that Social Security benefits could be slashed. They do not want to tell the people about lost Medicare services or fewer FBI agents or fewer border guards or weakening of immigration enforcement. Mr. President, are these kinds of drastic consequences really likely? Let us just take a look at the numbers. Proponents of this amendment claim that they can balance the budget while increasing military spending and cutting taxes for the very wealthy. But according to an analysis by the staff of the Budget Committee, to accomplish that and meet the government's existing commitments to retirees and Medicare, you would have to cut everything else literally 50%. Think about that for a moment, Mr. President. a 50% cut in law enforcement, a 50% cut in education, a 50% cut in immigration enforcement, a 50% cut in job training. The people in my state of New Jersey would pay a very high price for this amendment, especially if it is adopted in conjunction with other items in the so-called Contract with America. According to a study by the Department of Treasury, New Jersey could lose almost $1 billion annually for programs like education, job training, environmental protection, and housing. We would lose another $200 million for highways. And to make up for these and other cuts, state taxes would have to increase by 17.5% across the board, 17.5%. Our governor has been working very hard to reduce the tax burden on the citizens within our state. Her target is 30%, and with this change, we could be looking at a 17.5% increase in taxes. The balanced budget amendment also could wreak havoc on our state's economy. There is a study which analyzed how the amendment would affect the economy in the year 2003. According to the study, the amendment would mean that more than 178,000 people would lose their jobs, and the unemployment rate would increase by almost 5%, and personal incomes would decline by about 12%. Again, Mr. President, these are figures from a well-respected, nonpartisan research organization, and they should at least give us serious pause. I wonder if the American people have any idea that we are talking about these kinds of drastic steps. I doubt it. And one reason is that amendment proponents have kept the public in the dark. They refuse to say what will be necessary if this amendment passes. Why? Because the public would turn it down and it would remove this kind of hide-and-seek cover that is being used to present this deception, to suggest that the way we are going to solve our problems is by some formula change to our Constitution, which has as its structure the separation of powers and the responsibility for each one of those divisions of government. Okay, this is some jury charge material for the record. Ladies and gentlemen of the jury, the trial will now proceed. You will first hear the opening statements presented by the lawyers. Each party has the right to make an opening statement for the purposes of outlining for the members of the jury what each party expects to prove. The plaintiff's lawyer will make the first of the opening statements. Then the defendant's lawyer may decide whether or not to make an opening statement. The plaintiff's attorney always has the right to start the opening statements. The plaintiff then has the opportunity to present evidence. Once the plaintiff's case has been presented through the testimony of witnesses and the offering of exhibits, the defendant will then have an opportunity to present their side of the story by presenting their evidence. Each witness is first examined by the party who calls that witness to the stand to testify. The first time the witness takes the stand, it is called direct examination. Prior to taking the stand, the witness is sworn in by the clerk of the court. After the witness has been taken on direct examination, then the opposing party is permitted to cross-examine the witness. Some witnesses will be taken on redirect examination and even recross-examination. Those instances are rare, but they do occur. Some witnesses are even taken on voir dire examination, which may be conducted by either attorney. This also occurs very infrequently and is up to the judge whether voir dire is allowed. And ladies and gentlemen of the jury, do not get the voir dire examination of the jury mixed up with the voir dire examination of a witness on the stand. It is completely different. One takes place at pre-trial and the other takes place during the trial process. During the trial, the lawyers may at any time make objections to the introduction of evidence. The lawyers may also make motions concerning the law. Generally, most arguments made in connection with objections or motions are usually presented outside of the hearing of the members of the jury. They may be presented at the bench or after the members of the jury have been excused from the courtroom. The reason for this is because questions of the law and the admissibility of evidence do not involve the members of the jury. Those questions are decided by the judge, who is sometimes referred to as the court. It is the duty for each lawyer to make objections and motions which the lawyer believes are proper. Do not be influenced by the fact that a lawyer has made objections or by the number of objections which have been made. The total number of objections should have no bearing on the case. Do not draw any conclusions from the rulings in this courtroom, either as to the merits of the case or as to any views regarding any particular witness. Once the evidence has been presented, I will then instruct you as to the law which is applicable to this case. Members of the jury, you must follow and apply the law as I will explain it to you. Once these instructions are given, the lawyers will then have an opportunity to make their closing arguments. During their arguments, the lawyers will point out to you what they contend and have concluded is the evidence and what it has shown. They will present their conclusions from the evidence that has been presented. The plaintiff's attorney will make the first of the closing arguments. Then the defendant's attorney will present a closing argument. After the defendant's argument, the plaintiff will have the opportunity to make a further argument in rebuttal to the defendant's argument. Now, members of the jury, remember that what the lawyers say in their opening statements, in their closing arguments, and when making objections or motions during the trial process, none of these are considered evidence. The reason that the plaintiff goes first in each case is because the plaintiff has the burden of proof. After the closing arguments, you will retire to the jury room. While in there, you will begin your deliberations. Then it becomes your function and responsibility to decide the facts. You must base your findings only on testimony, on the exhibits that have been received, on the stipulations of the parties, and any conclusions which may be fairly drawn from the evidence. I estimate that this case will probably take 10 to 14 days to conclude. During that period, members of the jury, there will be recesses and adjournments of court when you will be excused. From this point forward until the case is over, do not discuss the case with anyone who is not on the jury. You may not discuss the case even with each other during the trial process. You must wait until after you have heard all of the evidence, my instructions as to the law, and the closing arguments before you begin any discussion. In fairness to all parties concerned with this case, you should strive to keep an open mind throughout the trial proceedings. You should reach your final conclusions only during the deliberations after having heard all of the evidence, my instructions as to the law, which I will give to you, and the lawyer's closing arguments. Until the trial is over, you must avoid all contact of any type with any of the participants in the trial. That includes the parties to the case, the lawyers, the witnesses, and any persons you see in contact with the lawyers, the witnesses, and anyone in the hallway or restrooms of this building.